Have you spent hours researching how to piece together a hodgepodge contract? Do you even know what you actually need in your service-based contract to ensure that you're protected? Today, I'm going over 5 big mistakes that I see creatives making in their contracts. Hi there, my name is Paige Griffith. I am the CEO and lead attorney behind The Legal Page. We are an online legal education platform and contract shop for small business owners. I'm an expert in all things contracts and have practiced for over 8 years. I've drafted hundreds of contracts in my career and have helped more than 10,000 business owners get legally legit in no time without all the overwhelm. Whenever I start reviewing someone's contract, I've started to pick up on a few things that continually come up as glaring issues. So, in an effort to help you avoid the pain that I see others face when they are in a legal dispute with a client, let me tell you what not to do. First, not having no downgrade language in your fee clause. Your fee clause should include your total fee, the retainer amount, information related to when the final payment is due, installment payments and when those are due, and liquidated damages and late fees. But I don't want you to forget to put legal wording in there about your clients not being able to downgrade the package that they agreed to. The no downgrade language serves as a crucial portion of your fee clause because it ensures that your clients cannot unilaterally reduce the fees or scale back services after committing to those in the agreement. This is especially important in service-oriented industries where your commitment to a client involves not only time and expertise, but also the opportunity cost of turning down other potential clients. Number 2, not choosing your own choice of law. So a choice of law provision, often called a venue and jurisdiction clause, ensures that you and your clients agree where a dispute is going to be handled. If you don't have this clause and say your clients are in another state or services are going to be provided in another state, you might very well be subject to the default contract laws in that state, which are likely going to be that your contract will be interpreted under those other state laws, and a lawsuit will then happen in the courts in that state. This obviously can be very costly to you and disadvantageous. So it's always best to choose your home state as the jurisdiction to interpret the contract, and then choose your local county to be the venue if a dispute arises. Number 3, not having clear intellectual property language. So if you're a photographer who owns the rights to the images that you take, it is important that you state as such in your contract. So can clients use those images for commercial purposes in addition to their personal use? Or if you're a virtual assistant, do you have any claim to ownership over the work product that you produce for the clients that you work for? What about coaches who share their valuable documents with mentees that they coach? Can those mentees then go and use those documents to create their own online courses and workshops? Probably not. And you want all of that to be explained in your intellectual property clause. So be sure to have comprehensive copyright language that goes over who owns the rights to the work product that you create under your agreement. And can your clients use those copyrighted works beyond just the intended purpose? Do you need to restrict your copyright ownership more than you think? Do you need a work made for hire clause if you're a contractor and you have a contractor-employee type of relationship? You need to make sure that this is all explicitly defined in your contract. Number 4, don't alphabetize your clauses. Sometimes people think it's best to put clauses in alphabetical order or just some random order. Don't do this. Organize your contracts from the most important clauses at the top to the least important clauses at the bottom. So fee clauses, cancellation clauses, all of those should be at the top, and then the more miscellaneous provisions should be at the bottom. This is because you're sending the contract over to your clients online, and we all swipe quickly to the bottom to sign. So most people are more likely to read the top of their contract first, so keep their attention there. And then also highlight, bold, and number your clause headings so it's super easy for your clients to navigate through and understand within your contract. Number 5, you don't communicate with your clients about what's inside your contract before sending it over to them. So you need to actually show your clients that you understand your contract, that you're a professional, and also open the door to a conversation about anything in your contract that your clients may not understand why it's in there or they may have a question about. So send your contracts to your clients in a better way. I want you to craft a more tailored email to your clients that re-emphasizes sections that you want them to look at in depth. So this is a key aspect of sending contracts because it creates what's called in legal terms a meeting of the minds, which is a mutual understanding between the parties of what's inside the contract that they are agreeing to. Instead of, here's your contract, click on the button, read through it and sign. Instead, you'll say, thanks so much for talking with me. I'm excited about your project. Before we get started, let's sign a contract so that we're all on the same page. And then here are a few key things that I wanted to point out. You're going to bullet point those. So clause 2, clause 3, clause 6. What are the ones your clients should be looking at? And then in your own words and layperson terms, explain what those clauses mean. This is super, super important when you're sending your contract so that all of the understanding is mutual. You, of course, know your contract, but your clients really need to know what's in it. These are just a few of the biggest concerns that I have when creatives send me over their contracts to review. But let's face it, you didn't go to law school, and you probably want to figure out a turnkey process to get your contract legally legit in the least amount of time with the littlest cost. Well, I've provided a link below this video for you to check out our contract templates at thelegalpage.com. We have hundreds of customized contract templates for each specific industry, and I've given you a little extra discount to boot. But if you're not quite ready to buy a contract yet, and you'd like to hear more from me about contracts, specifically, I would like to tell you 3 of my best kept contract secrets and 4 things you can do right now to have a better client contract that will actually protect your small business. Head over to my free legal class at contractclass.com. I hope these 5 tips were really helpful for you, and I put out new YouTube videos every other week, so I'll catch you in the next one.